Good evening, everybody. I once again welcome you to this evening gathering. As all of you all know, media plays a vital role in molding the opinion of the society, and it is capable of changing the whole viewpoint through which people perceive various events. While a media shackled by government regulation is unhealthy for democracy, the implications of continued unaccountability are even more damaging. So today we have got an eminent speaker to speak on trial or media. I hereby call upon Mr. J. Ravindran to welcome our guest today.
Good evening, everybody. I wholeheartedly welcome Mrs. Madhavi Divan, Senior Advocate and Additional Solicitor General of India, for accepting the invite to the topic trial by media. She is an expert in media law, and in fact, 10 years back, she has written a book called Facets of Media Law, which is the Bible as far as media laws are concerned. Today, media is very powerful weapon which can be portray a right person as a wrong person and a wrong person as a right person. I am thankful for accepting my invite once again, and I request the speaker to deliver the address.
Thank you very much for this very kind invite. Am I reasonably audible?
Yes, you are audible, ma'am.
All right. So thank you very much for extending this invite, and it's a great pleasure to meet a bunch of lawyers from Chennai. Actually, I have not had the privilege of appearing before the Madras High Court. However, I have traveled to Chennai several times, both on work and for pleasure. And the last I think I visited was for the Law Asia conference. Unfortunately, travel is not possible for the time being. But I have to say that if there is, in these very, very unusual circumstances that we are living through, if there is a silver lining, then perhaps it is this, that we are able to meet on these virtual platforms. And actually, one very interesting opportunity that this pandemic has thrown up is the possibility of a more pan-Indian bar, because we find that not only are we able to appear now in courts, which we may be in different locations, but we can easily appear in a different court, and also for for these kind of interactions where the bar from different parts of the country can meet on the same platform, and we can get to know and understand each other better. So thank you very much for this opportunity. Coming to today's subject of trial by media, and this has of course been a hot potato for a very, very long time. This is of course very topical today for many reasons, because of course this collision, or this apparent collision between the freedom of speech and expression on one hand, which is a very, very important right, a fundamental right under Article 19(1)(a). On the one hand is the freedom of speech, and that includes the freedom of the press. We do not, as you know, in India, under our constitution, the press and the media do not have an independent right. It is the very same right that is available to the citizen, and it's a very important right that is available to the press and the media as well. There is also the right to information that we have as citizens, which we get from the press and the media. So that is, on one hand, it is a 19(1)(a) right, and on the other hand, we have the right under Article 21, which is a many-splendored right, as we know, and that includes the right to a fair trial and access to justice. So we have this apparent collision between these two rights, and it's a very difficult question on how much reporting, how far one should report, and where do we cross the Lakshman Rekha into something that could impact the administration of justice. It's a very difficult question and a very thin line often. But that apart, I'd also like to touch upon today the fact that this is a subject which, it's also very, very important for us as members of the legal fraternity, because ultimately we are the greatest stakeholders in the justice system and in the rule of law. It also throws up very important issues for journalistic propriety and for the journalistic fraternity as a whole, the role of the press in democracy, and so on and so forth. So these are broadly some of the issues that I will try to touch upon. This issue of trial by media is something that rankles us perhaps more than ever before because of the emergence of a new media now on the horizon. It's been, of course, some years now that social media seems to have taken at a certain level a center stage, and the sheer ubiquity of the social media, takes this to a very different level. Now, the difference between social media and the traditional media is, of course, that, you don't need to be a journalist anymore. You do not need to be a fact finder who reports, who's reporting from the ground. You can be anyone. You can be a lawyer, you can be a layperson, and it is a very democratic medium in many ways because it's for the people, of the people, by the people. And yet there are problems because of the fact that it's not a fact finding. So there's a propensity for fake news. There is sort of opinion and fact is kind of blurred. And because of the self-perpetuating nature of social media, the manner in which it goes viral, it can, things said on social media can acquire a kind of higher, sort of a larger than life kind of credibility, which can be problematic in some cases for the delivery of justice. Now, what do we mean by trial by media? It was sought to be explained, the expression trial by media was sought to be explained in a judgment which was delivered about 10 years ago. This was the case of R.K. Anand versus the Delhi High Court. If you recall, there was a very infamous case, the BMW hit and run case, which took place in Delhi, where a young man from a very influential family mowed down some people on a road on an avenue in Delhi. And eventually during the trial, a TV channel did a sting operation where they found this unholy nexus between the defense lawyers and the prosecution. And in that context, what was brought up on the side of the defense was that, look, this is a trial by media, and the court rejected that and said, no, it is the duty of the media to bring out these issues, to expose this, and therefore this sting operation was completely justified. Now, in that case, this is the manner in which, and I'd like to read this out, how they define trial by media. The court said, and I quote, "The impact of television and newspaper coverage on a person's reputation by creating a widespread perception of guilt, regardless of any verdict in a court of law. During high publicity court cases, the media are often accused of promoting an atmosphere of public hysteria akin to a lynch mob, which not only makes a fair trial nearly impossible, but means that regardless of the result of the trial, in public perception, the accused is already held guilty and would not be able to live the rest of their lives without intense public scrutiny." Of course, at that time, 10 years ago, perhaps the social media wasn't... I'm sorry? It wasn't so popular at the time, so that has not been mentioned, but that is a great change which has taken place in the last 10 years. Now, of course, trial by media is a very, very old thing, even in India. It's a very difficult challenge. It has been for ages now, because perhaps the foremost case in independent India, which caught the fancy of people, was the Nanawati, the famous Nanawati case, which you're all very familiar with. And it was a case of, which involved a very sensational story of crime and passion. And as you all know, a naval officer by the name of Kavas Nanawati had shot dead his wife's paramour, one Mr. Ahuja. Now, at the time, there was a tabloid by the name of Blitz, owned by a Parsi baron, and that journal took up this story, and it was really portrayed as a very polarized debate actually emerged, because this gentleman, Kavas Nanawati, happened to be from the Parsi community, a very tiny minority even in Mumbai at the time. But he was a very honorable officer, and therefore this image was created of a very someone serving in the armed forces, and who had been out on duty, and when he was away, his familial harmony had been disrupted by this interloper, Mr. Ahuja. So Kavas Nanawati actually got a lot of sympathy at the time in the media, and there were a lot of very sensational headlines that the Blitz carried at the time. For example, the 3 shots that shook the nation. Now, eventually, what happened there was that the jury acquitted Nanawati by an 8-1 verdict. And that's interesting because Nanawati himself, after committing the crime, had turned himself into to the police. But the sessions judge, of course, disagreed with the jury's verdict, and eventually it went to the Bombay High Court, and the division bench convicted him. Thereafter, it was upheld by the Supreme Court. But eventually, he spent very few years in prison, even though he got a life sentence. And there was a lot of pressure even at that stage, which was brought to bear, and eventually he was let off. There was another case, and I might mention this, that this case actually really caught the public attention and the public's fancy to an extent that there was merchandise being sold on the streets of Bombay at the time. There were Nanawati guns, Nanawati pistols, which were being sold, and towels named after Ahuja, because it was said that at the time that he was shot, he had just come out of the shower and he was clad in a towel. So there were towels being sold under his name. So there was all this popular culture around this case. Then, as I mentioned, there was another case way back in 1873 in Calcutta, which was also a very sensational case, not very dissimilar from the Nanawati story. And there too, you will see how the public opinion prevailed in that case, because that was a case where a government employee called Nobin Chandra Banerjee, he beheaded his young wife called Elokeshi because he suspected that she was having an affair with a mahant, a high priest whom she had gone to for medication. Now, he severed her head with a fish knife at the time, and yet, there was just so much public opinion, and Puritans of the time felt that, this man had been so wronged, and there was, this unchastity attached to his wife, and he had only avenged his honor. That was the kind of public opinion which had built up about the case. And eventually, there was the public would throng to the court at the time, so much so that the authorities had to impose a fee on public entry in the courtroom, just to prevent the crowds from gathering. And we are talking of 1873. And there was, again, a lot of popular culture around it, because there were Kali Ghat paintings which were etched, and then there were plays that were centered around this theme. And eventually the jury again acquitted Nobin Chandra Banerjee. The Englishman, the judge was an Englishman, and he of course disagreed with that verdict. Eventually it went to the Calcutta High Court. The Calcutta High Court gave him a life sentence, and they gave the mahant a 3-year sentence for adultery. But what was interesting is that there was so much pressure brought to bear because of the sympathy that had been created for the murderous husband, that eventually they had to let him off in 2 years, whereas the Mahant, he had to serve his sentence for 3 years. So, you look at that irony of that case. But these were, two old cases, of course, 180 years apart, but it will tell us that trial by media is something that we've had to deal with for a long, long time. Of course, more recently, we are seeing on television the debates surrounding the very unfortunate death of a young Bollywood actor, Sushant Singh Rajput. And of course, we have seen that whenever such cases have come up, there has been, this sort of almost a media circus, unfortunately, with lawyers coming, those appearing in the case, those not in the case, potential witnesses presenting themselves before news anchors and quite willingly being grilled on television, which, frankly is quite baffling. But this is the way it has been for a while, and there are other cases where we have seen medical experts happily volunteering their services in the past. Investigating agencies have also come. So this ends up like a veritable media circus, and the difficulty, of course, has been exacerbated with this social media coming to the center stage, where it is so easy to whip up and drum up support for one side or the other side, and to paint a particular narrative. Now the difficulty arises because if when examining the hard evidence eventually of the case, if the court finds that the guilt points in a different direction from what the media has painted, then it becomes very, very difficult, because all sorts of insinuations and accusations will be then made. So it becomes very, very difficult for a judge then to act completely unclouded by the kind of pressure that is brought to bear in such cases. Now, the ideal, in fact, traditionally it was believed that, look, judges have to be completely immune to what is said in the media. It shouldn't bother them at all. But that is frankly, in times where reporting is so relentless, I feel that might be too idyllic to expect. And as far back as in the 1940s, there's an interesting quote from Justice Frankfurter in a US Supreme Court judgment, and I'll quickly read that quote to you. It says, I quote, "No judge fit to be one is likely to be influenced consciously except by what he sees or hears in court and by what is judicially appropriate for his deliberations. However, judges are also human, and we know better than did our forebears how powerful is the pull of the unconscious and how treacherous the rational process. While the ramparts of reason have been found to be more fragile than the age of enlightenment had supposed, the means for arousing passion and confusing judgment have been reinforced. And since judges, however stalwart, are human, the delicate task of administering ought not to be made unduly difficult by irresponsible print." So while pointing this out, there are a couple of points that I'd like to make, which may not be directly on the issue of trial by media, but they are nonetheless important. Because in this whole cacophony of shrill debates that take place on prime time or on social media, and I'd say more so on, say, television, because that is still, a traditional media. That's not social media. It's generated by professionals, and that's what I mean by the conventional media. In this whole noise of these shrill debates, where there might be at a certain level, very disproportionate coverage, there are so many issues of national or international importance which just sort of pale into insignificance. And what tends to happen when the media becomes commercialized, where profit becomes the driving motive, and this has been the case in India for a while now, that the consequence is sensationalization of news and tabloidization. So that is a problem, because when that is driving you, when the TRPs are driving you, you are forced to cater more and more to the sensational. And in the process, it's not just the quality of news that declines, but also what tends to happen is that the citizen is not getting adequate access to quality reportage and the real stuff which should matter. Because the difference, although as I said, 19(1)(a) is a common right for both the citizen as well as the press and the media, but nonetheless the press has still been described as the trustee of the people. And why trustee? Because you and I as citizens, even though we may be on social media, we cannot be fact finders. For that, we have to depend on the traditional media. They have to go to this, they have to fact find, they have to report from the ground. And therefore, they determine at a certain level as to what we know and what we do not know, what we see or what we do not see, what we hear or do not hear. And therefore, they are directly or indirectly, they are impacting the quality of the citizenry. And so if the citizen gets only a sort of disproportionate coverage, and of course, I mean, the citizen seems to want more and more of, salacious or voyeuristic coverage. But what tends to happen in the process is a sort of dumbing down of democracy as a whole, because ultimately the citizen is not getting what he or she actually deserves, and for which the media is a trustee. So I think that in all of this, it's almost as if, these, whether, you'll remember not just Sushant Singh, but there were other cases like the Sheena Bora murder case and the Arushi trial. Of course, these were very important cases. There's no doubt about that, and very sensational cases. But I do not know. I mean, it's something to think about. That wasn't it very, very disproportionate coverage? And was it not kind of paling into insignificance or relatively less significant other news stories which may be very, very important for us? So that is also something for the media to introspect on. The second thing I'd like to raise here is that, sometimes when, tragedy like this strikes, like this Sushant Singh's unfortunate death, there's a privacy factor. There's a privacy factor which, oftentimes as commentators, whether on social media or the media generally, we tend to be very, very insensitive. And I think that is something to really think about. I remember being very struck by it when the Arushi murder case was being reported. And we found that it was just awful, because there was this a 14-year-old girl who had been murdered, and all these very lurid stories about her were being conjured up, of all sorts of sexual escapades, all imagined stuff, which, very, very difficult. And ultimately, you are destroying the reputation of a child who is not there to defend herself. So this kind of insensitivity is again something that we have to think about. And privacy is now, of course, a fundamental right under Article 21. Now, one may argue that the privacy privacy is not a right which the dead can have, but I think there is a right to dignity even in death, and that is something that, as citizens, as the media, we want to think about. Now, it's also interesting that apart from, these criminal cases, there are cases where there is an attempt by affected people to drum up a media campaign in order to steer the verdict in a certain direction. And sometimes, the judges deciding are obviously can be quite oblivious of this. And this is something to think about and something to be alert about. I will give you one example, because a few years ago, I was asked to speak on this very subject. It must be about 5 or 6 years ago, maybe, at the Judicial Academy in Bhopal. And at the time, I had done some research on this, and there was an interesting case which was widely reported in the media. It was called, it was about the demolition of illegal structures in a high-rise building in Mumbai. and the top the top floors of that building had been ordered to be demolished, and therefore the residents had to vacate the building. Now, it had several rounds of litigation all the way to the Supreme Court. The matter had been finally determined, and those floors were to be demolished. Now, what happened is that thereafter, about maybe a year and a half after the final judgment was delivered, a bench of the Supreme Court issued notice, suo motu notice, and a stay was granted. And I remember, because the senior judge was a very conscientious and a very, a person of great rectitude. And he said very frankly that, look, I was watching the visuals and I couldn't sleep at night because I thought of the plight of these people who are going to be dishoused. And it is true that on television, there were all these visuals of, these weeping residents, and they were sort of saying their prayers and holding sacrifices, yagnas and all that kind of thing. So very, very dramatic portrayal on television. Now, it later transpired that these residents had apparently engaged a PR agency. And the PR agency later emblazoned and bragged on its own website that, we launched this media blitzkrieg on television and on radio and other media, and eventually we were able to get a good order for our client. So this is also what is being, unfortunately, this is the kind of, the manner in which the media can be used and misused, and the manner in which it can impact the justice delivery system. Now, there is, of course, no denying that the media has played a tremendous role in certain cases in, highlighting, say, very shoddy investigations, in really launching campaigns which have helped bring the guilty to book in very, very gross cases. And I'll give you a few examples, like there was a case called the Priyadarshini Mattu case of rape and murder of a young woman in Delhi. There was the Nitish Katara case, again a very infamous case. The Manu Sharma case, for example, where there was a very shoddy investigation leading to an acquittal in the first round, and it was only on account of the media trial, a very relentless, not media trial, but a media campaign, a very relentless, and by civil society, which eventually led to the High Court issuing notice once again suo motu, and an investigation took place all over again. Eventually, the guilty were brought to book. So, what we're discussing today is what are the fine lines? What is the Lakshman Rekha between good reportage, permissible reportage, and something which veers into interference with the administration of justice, which is found under the definition of criminal contempt. Now, this is a very difficult line to draw, because it is important that the media reports, even on, sometimes it is, under the Contempt of Courts Act too, it is permissible, even in pending cases. If it is bona fide reporting, there is no difficulty with it. But again, there has been some debate on what should be pending, what should be defined as pending, and what is not pending. There was a Law Commission report also, which has made suggestions in 2007 that the starting point of a criminal case, that is to come within the definition of pending, should be the time of arrest of the accused and not the time of filing the charge sheet. Now, there will always be debate on this issue, but in the Sahara case, that's a landmark judgment, 2012 judgment of the Supreme Court, Sahara India versus SEBI, a similar issue came up, because in that case, the court took umbrage at the fact that there was a confidential proposal which was made public in the press. And the court felt that now, enough is enough, that some fine line had to be drawn. And therefore, the matter was referred to a constitution bench. Now, there too, the court considered, and this matter was argued for a very long time before the Supreme Court, several days on end, and some very leading counsel appeared in this case. And frankly, I would say, fortunately, the court did not lay down straight-jacketed media guidelines, because one does realize that it's very difficult. Each case varies, and you cannot lay down any set rules on what amounts to traversing that line of interference with the administration of justice. But what the court did hold in that case was that because the court was juxtaposing the right to a fair trial under Article 21 with the right to free speech. And what the court held was that, look, in certain cases, you can apply what are called, quote unquote, neutralizing devices and temporarily postpone the media reportage. So, well, ideally, even this should not happen, because, oftentimes it's very important to report contemporaneously. But of course, it's got to be balanced coverage. It's got to be bona fide coverage. And this case has been applied in, or attempted to be applied in, several judgments subsequently. In some cases, it succeeded. Oftentimes, it did not succeed. For example, in the Asharam Bapu case, it did not succeed. Moving on, there is a couple of points that I'd like to make on activism and advocacy, because this has also raised certain issues about trial by media. For the last several decades, as we know, the Supreme Court in particular has been an activist court, taking up matters of wide-ranging importance in covering issues which are real matters of moment, great public importance. So whether it's to do with the constitutional matters, human rights matters, matters affecting the polity, society generally, and matters, as I said, of great moment. Now, in this PIL jurisdiction, the emergence of this PIL jurisdiction has naturally spawned the emergence of activist lawyers who have taken up some oftentimes very, very good causes. Now, the difficulty arises sometimes, and this is something to flag. It's been mentioned in the Tehseen Poonawalla judgment recently, that when, as an advocate, you have a certain duty to the court, you are appearing as an officer of the court. Now, when you are wearing multiple hats at the same time, if you are, donning multiple mantles, for example, if you are arguing the case, at the same time, you are gathering evidence, you may be also, appearing on television in those very cases simultaneously. You may be reporting on social media. So all of this, wearing too many hats at the same time, it can be problematic. Now, it's very difficult to draw a firm Lakshman Rekha in all cases, but the one thing that rather than wait for the court to act in the matter, I think we should introspect as a legal profession. We should, try and check ourselves rather than allow anyone else to do that for us. Because, ultimately, as a legal fraternity, it is we who have the greatest stake in the rule of law and in the justice delivery system. So we cannot have, while we must support fair and free reportage, we must also ensure that there is no emergence of a parallel system of justice or the creation of an expectation that the outcome of a case should be in a particular way and no other way. So that would be very problematic. It would have an immediate impact on the rule of law, on the justice delivery system. And as stakeholders in that system, I think we would be affected as a legal fraternity generally. Now, one last point that I will make is, on the open justice system. Now, again, open justice, that is for our courts to remain open to the public to access, is an extremely important value in our system. And the reason is obvious, and that is that the public has a stake in the delivery of justice, and it's not confined to the litigant's own case. Any member of the public should be able to walk into a courtroom and watch the proceedings, because, as they say, justice must not only be done, it's got to be seen to be done. That apart, it's very, very important, and I would say even more in times of social media, where the manner in which the social media works is that, for example, on Twitter, you have just a limited number of characters. So that does not really allow for a more nuanced debate. And therefore, it's all the more reason that the public should be exposed to how the court delivers justice, how the system works. And this is one of the justifications for the open justice system. Now, ultimately, open justice also keeps all the participants in the system, whether it is we as lawyers or witnesses or everybody. It keeps everybody under watch, and there is a public check in that sense on the manner in which proceedings take place. But having said all of that, it must also be acknowledged that open justice is not an end in itself. The idea, it is a means to an end, because the idea is that justice must be delivered. That, for example, witnesses should not be emboldened to tell untruths when they are in the box. They are also being watched. Everybody is being watched. And therefore, that is the end, justice delivery. But there has been this debate on whether we should have televisation of the court proceedings, because ultimately, when the reportage takes place, say through tweets or blogging or or it's often said that it's very, very skewed reporting, it's imbalanced reporting, and so on. So one of the arguments made in the Swapnil Tripathi case on televisation was that everybody should be able to access it, everybody should be able to see how proceedings take place, and then you don't have to physically enter the court. There can be interns, there can be just generally members of the public sit wherever they are and watch the proceedings. The court is, of course, there held that on a pilot basis there will be televisation of court proceedings. But having said that, there is also, I think we must talk about this as the bar, because ultimately we must ensure that while public gets access to open justice, it should not be degenerating into a publicity contest. That's also very important for the purity of the justice system, for the integrity and efficiency of the system. So I think, these are very difficult challenges to balance, but I thought that I would, leave this food for thought with you. I think I've said quite enough, and maybe I will hand back to Mr. Ravindran.
Ma'am, thank you so much, ma'am. Is anyone who would like to interact? Mr. Ravindran, yes.
Thank you, Mrs. Divan, for addressing this seminar. I just have only one thing. I don't know whether you agree with me or not. investigative journalism is a part of media journalism. Now, the concept of investigative journalism is more being misused, according to me, rather than being used for, and it is an attempt to interfere with the judiciary and to take judiciary in a wrong side. There is a attempt. This is what I feel in several number of cases. I just want your opinion on that.
You see, I would not make such a generalization, frankly, because I feel that there are a lot of cases in which investigative journalism have made a huge contribution. I don't think there's any doubt. And there are several cases. I mean, for example, this very case that I mentioned, the R.K. Anand case, I think that, it was a sting operation. And yes, the court also comments on the fact that it was sort of, they sensationalized it a little bit. But in the end, there was this nexus between the defense and the prosecution, which got exposed. And that is very, very important. Now, it is true that it was in the midst of the trial. It is true. But I think, in answer to your question, I would say that it would vary from case to case. I don't think we can generalize. And I think, therefore, I would say that whether for the journalistic fraternity or for us as lawyers, we need to introspect and self-correct. And the answer, in different cases, it would mean different things. But I don't think we can have a gag on investigative journalism. It's a very, very important part of our system.
Ma'am, one more thing, ma'am. Don't you think that media trial amounts to contempt of court? Because is it not prejudicing a trial, ma'am?
Yes, so I think I said that, you see, under the Contempt of Courts Act, one of the definitions of contempt is undue interference with the interferes, or it says, interferes or tends to interfere or obstructs or tends to obstruct the administration of justice in any other manner. So I think, yes, it falls under the definition of criminal contempt. But where one ventures or one sort of falls foul of that Lakshman Rekha is a matter to be determined in each case. And I think that the answer is really for everyone for the media and the press to report freely. But I think it's also important that we self-correct as professionals. So whether as lawyers, when we are going on TV debates, or whether as news anchors, at every level, I think every profession has got to self-correct rather than wait for someone else to come down on them. So I think it's a matter that varies. It's an issue that varies.
Ma'am, in Arushi case, the media drew a flag.
Yes. So as I said, I gave you the example of the month where they really did a very good job.
Yes, ma'am.
Likewise, in this hit and run case. So they did. I mean, there are so many cases where they have done a tremendous job.
Yes, ma'am. Ma'am, thank you so much for having spent your valuable time here, ma'am.
Thank you very much.
Heinous crimes must be condemned, and the media would be justified in calling for the perpetrators to be punished in accordance with the law. However, ma'am, as you said, the media cannot accept the function of the judiciary and deviate from objective and unbiased reporting. Thank you, ma'am. Thank you once again for having joined us, ma'am.
Thank you so much. So kind of you. Thank you.
Thank you.